Hello and welcome to the third annual Completed Life Fall Conference. My name is Sarah Kiskaden-Bechtel, Program Director for the Completed Life Initiative, and I will be your host today. Through its annual conferences, the Completed Life Initiative has established a tradition of addressing thought-provoking ideas at the end of life. The conversations within each conference session are intended to reset our traditional norms around death and dying, and to invite a new standard to emerge through rigorous public discourse. What does it mean to live well and die better? How can any one person, regardless of country of origin or life circumstances, embrace their individual autonomy at the end of life to ensure a good death? Our third annual fall conference was designed as a gateway to help you fully examine these core considerations. Today's session 1 examines the amendment to a state's residency requirement for patients seeking aid in dying in the settlement that decided Gideonse v. Brown et al. 2022, the first in the nation to successfully challenge a state's residency requirement. Proof of Oregon state residency, such as voter registration and lease agreements, no longer apply as eligibility criteria for patients seeking a medical assistance in their death. What are the practical implications of Oregon lifting its residency requirement? And further, given the Privileges and Immunities Clause of Article 4, Section 2 of the Constitution, what are the ensuing implications and perhaps obligations for other states where MAiD is legal to neutralize their own residency requirements? For this session, I have the honor of welcoming Kevin Diaz and Dr. Nicholas Gideonse to the Completed Life stage with moderator David N. Hoffman, JD. Mr. Kevin Diaz, JD, represented Dr. Nicholas Gideonse, MD, the plaintiff in Gideonse v. Brown. Kevin Diaz is the Chief Legal Advocacy Officer and General Counsel for Compassion and Choices. His work focuses on improving healthcare and expanding choice for the end of life throughout the United States. During his over 20-year career in public interest law, he has worked to protect the liberty and enhance the dignity of people through the use of integrated advocacy. Dr. Gideonse is a family doctor whose practice interests include opiate addiction treatment, particularly in pregnancy, maternity care, end-of-life care, and Oregon's death with dignity law, as well as community standards for pain treatment. After his residency training, Dr. Gideonse practiced in rural Oregon. His educational focus is on the patient-centered medical home model of primary care and barrier-free access. Our moderator for this session is none other than David N. Hoffman, JD, who is a healthcare lawyer and clinical ethicist in New York, where he is assistant professor of bioethics and full-time core faculty member of the Columbia University master's program in bioethics. He also teaches in the areas of law, medicine, and ethics at the Albert Einstein College of Medicine, where he holds an appointment as a clinical assistant professor. He also serves as the Chief Compliance Officer for Carthage Area Hospital and is admitted to practice in New York State and the federal Southern and Eastern District Courts. Professor Hoffman is also an esteemed founding member of the Completed Life Initiative Steering Committee. Whether you are new to our Completed Life community or are a returning attendee, these sessions are invaluable learning tools meant to empower you to have an informed conversation for yourself and with your loved ones about the completed life. I invite you to ask lots of questions at every session. Before we begin, please be aware that you may input your questions into the Q&A feature located on the lower right-hand corner of your screen. Please feel free to submit your questions throughout the event, and later on we will return to your questions for an interactive Q&A with our esteemed panelists. If you'd like assistance with closed captioning, you may toggle on the box located in the lower left-hand corner of your screen that provides captioning for the spoken words of our event today. And finally, the recording of today's event will be published after the conference concludes. And now, without further ado, let's begin.
Thank you, Sarah. And good morning, Kevin and Nick, especially early morning for the two of you on the West Coast. So grateful to be able to spend this time with you to discuss what is really kind of the perfect topic for the first session of this, our third annual Completed Life Conference. Um, and just fascinating how we got here at a point where the state of Oregon has acknowledged that the residency requirement isn't necessary. And so I guess my first question to both of you, and I'd like to start with you, Nick, is how did we get here? How did we move from the adoption of the Oregon medical aid in dying law 20 years ago with the residency requirement to today where you concluded clinically, and Kevin, you advocated legally for its elimination?
Yeah, David, as so often in this area, it's about following the patients, and um, as the years accrued, um, more it became more and more apparent that there were significant borders to my patients who lived in Washington and talking to me about end of life choices. My practice is in Portland, Oregon, which is right across the river from Vancouver, Washington, part of the same metro area. Um, about 17% of my patients live in Washington State. It's not unusual for folks to come across the river for medical care. And I'd had gradually increasing number of occasions where patients had wanted to talk about end of life options and the residency became a barrier. Um, Additionally, for at the beginning of the pandemic was the first time I went to a national conference on medical aid and dying. So many states now have the practice that we know what the standards look like, and the residency requirements seem much more arbitrary than it did 20 years ago when we were out on our own in Oregon launching, what was to be a successful experiment in end of life care.
Indeed. And Kevin, same question to you, but with a slight twist. I know you weren't responsible for the drafting of the medical aid in dying law in Oregon originally. It was the act of the legislature and an inherently political process of compromise. But can you talk about what the residency requirement was intended to accomplish from a legal and a public policy perspective? And then what, from your perspective as an advocate, changed over the course of the last 20 years to bring us to where we are today?
So originally it was a ballot initiative. So there were certain considerations about what the voters would think and what the fears were that were raised by opponents. And one of the fears that I think proponents at the time didn't believe would take place, but we really just didn't know because we were the first state,
Mhm.
but there were, kind of allegations or fears that were raised that people would come to Oregon and then bodies would be washing up on the coast because people would want to use medical aid in dying as the sun set. And while we may now think of that as being somewhat preposterous, and we may have thought that back then, we really, really didn't know. And now that we have all of this data, we have all of these other states that have been authorized, I think it's pretty clear that there's no real state interest that can be articulated that would legitimately even try to bar patients from coming and accessing medical aid and dying. And that's particularly true because people are at the end of their lives. And so it's just not something that you're going to see a large number of people being even able to do.
Absolutely. So, Nick, talk to us about what those conversations were like with patients when the residency requirement was still in place, and how you manage that as a clinician. That I assume must be must have been, especially early on, a tricky conversation. What were those conversations like?
Well, I would suggest that they were both confusing and consternating, right? I mean, uh, you're in your clinical day, you're seeing the things that are in front of you, right? You're picking from the menu that's presented to you. And the conversation with the patient, I remember one where I was not really aware that this new consultation for a prescription for medical aid in dying was coming from someone from Washington State until we sort of got to the end details part of the conversation. I mean, we'd already established that the patient had a terminal illness, that they were competent to make this decision, that they considered there are other options, et cetera, et cetera. Even had begun to talk about what the actual process would look like, what the medications would look like. Whereupon, at that sort of point in the conversation, essentially going through the check boxes, it became aware that the patient had been referred from Washington, was a Washington resident. And that was, obviously deeply disappointing and consternating for both of us, me not sure what steps would occur next. A different conversation I can recall specifically was a patient I have known for a long time with some heart failure, not necessarily right in the terminal 6 months of his life, but beginning to have these conversations. And again, where we'd worked together on a number of health issues, where I've been his primary care physician for many years. I sort of felt like this barrier came up to where I had to sort of not stop the conversation. Of course, I wanted to continue to explore his concerns and what he was expressing. But I had to inform him that I could really not be involved as a participant were he to choose that option, that we'd have to find other doctors.
And was this a problem when Oregon was the only state that had a legal means of medical aid in dying? And how did that change as more states adopted their own laws in terms of your individual practice?
Well, for my individual practice, both of the conversations I referred to occurred at times where Washington, I believe the second state in the country, had already approved its initiative. So again, it felt even more artificial.
Understood. Kevin, as a lawyer, what did you tell doctors that reached out to your organization, Compassionate Choices, about what their legal prerogatives were and what their legal restrictions were in the days when many states did not have medical aid in dying laws? How did you approach that as a counselor?
Well, we try to provide information. I didn't necessarily represent all the physicians that spoke with us. So, it was a number of years ago where we really started to think hard about challenging the residency requirement, and came to the conclusion that it was unconstitutional. And some of that was raised because of the difficulties we had heard in Southwest Washington and because of a change in healthcare provider affiliations, and essentially a merger that took place in Southwest Washington, which made the largest hospital Catholic affiliated healthcare entity. And because of that, we started to tell people what we thought, which was, we don't believe that this is constitutional, but it's the law, and so until there's a change either in the law or it's challenged in court, you still need to follow the law. It's unwise for people to go rogue and try to do something without kind of the proper footing, and you just never know for sure. So we ultimately then we decided to bring the challenge.
And just so our community, which is a diverse community, lawyers, clinicians, social workers, advocates, people who this is an issue for them personally, just so that they're clear that that merger, that became an issue in the area where Nick practices because of the ethical and religious directives that constrain Catholic hospitals from getting involved in medical aid in dying. What role did that play in the sort of strategic discussion about, yeah, this is now not just a theoretical constitutional infringement, this is affecting people's access to care? What was the thought around that issue?
Well, I think that the thought for us, it just highlighted the arbitrariness that Nick is talking about. And it just made absolutely no sense that someone would have to disrupt their continuation of care with Dr. Gideonse and suddenly have to seek another medical provider for something that he was able and willing to provide them should they go make it through the entire qualification process. And one of the things we always try to look for in selecting cases is what just doesn't make sense, what just seems absurd or completely nonsensical in the approach to delivering end-of-life care. And if something like that presents itself like it did in this circumstance, then what are the legal claims that we might be able to bring, or what are the legislative fixes that we might be able to advance that will resolve that issue and make sure that people get the best possible care at the end of life?
Nick, when this first presented itself as an issue in your practice, what did you do? Were you making referrals to colleagues across the border or referring patients to organizational resources like Compassion Choices? How did this play out on the ground?
Yeah, absolutely. Well, in the second case I mentioned, let's call him Harvey, whereas my own patient, this is an ongoing conversation without like a specific time limit or a specific request to enact directly. So in that sense, I felt like I could lay the groundwork for what his future options might be, maintain the physician relationship, just knowing that that barrier would be in the future. In the first case that I had mentioned, the direct referral case where it wasn't really apparent that the Washington residency the Oregon residency was going to be a particular restriction. That did mean sort of blindly falling back onto resources, good resources. There's a group called Washington End of Life Choices Washington that can manage that. So ultimately, I don't really know what that patient found or was able to come with. So again, as a clinician patient in front of you, it sort of just felt like a dead end.
I asked that question because in a little while we'll be talking about the implications for the dropping of the residency requirement going forward as people learn through programs like this and other avenues that they can gain access to medical aid in dying. So I want to go back now to Kevin. What was the conversation like with the state of Oregon? And why don't you, by the way, tell everyone who Brown is? But what was the conversation like with the state of Oregon about why you brought the lawsuit and why a settlement might make a lot of sense?
Well, it was a good conversation, productive conversation, and Brown is our governor, Governor Keith Brown. There were a number of defendants, and so we worked with the state's attorney that represented those particular clients, and it was cordial and professional. And I think that the thing that people really want to know about is the thing we don't know, which is what did their attorney tell their clients, and how did they advise their clients? Very soon into the action, we entered into negotiations. We were open to that, of course. And shortly thereafter, and of course, with the number of clients that they had, there was a lot of going back and forth amongst them. So there was a certain lag time that took place. But ultimately, they proposed a settlement that kind of gave us everything that we could get from them, really. And while we always would love to get a judicial determination on our claims because we believe we had very strong claims, we have to recognize that anytime you sue the state or a state entity, they, as a kind of a pro forma matter, they will always assert certain institutional defenses because that's just what they do, and they're never going to let go of those. So while we would love a judicial determination, by coming to a settlement that essentially gave us the relief that Dr. Gideonse informed us made him feel comfortable to be able to prescribe in the circumstances that we were suing about. It just made sense to settle. And, one component of that settlement was that the state would advance a bill to correct the language. And we recently just saw the language of the bill, and it tracks the settlement, and we're very pleased that that's moving forward. In fact, we just saw it yesterday.
So, Nick, indulge Kevin and I to dive into the law for just a few minutes, because I think our community would like to better understand what are the provisions of the settlement and what does the settlement not accomplish. And I'm thinking here particularly about the fact that the case was discontinued against the governor. So the governor is not a settling party. And what was that about? What was their interest? What was your concern? And how did you get to yes?
About letting the governor off?
Right, so that the governor was
yeah,
not a party to the settlement.
Right. They raised certain defenses that they were going to bring about if we kept the governor in, and to expeditiously settle the case, they wanted her taken out. And so we went back, did some research, and then also considered the fact that we had other statewide actors that were still parties to the suit. And we didn't think that including the governor would in any way minimize the relief that we would get. And so we decided it made sense.
So talk to us a little bit about what the future holds if the legislative action is not successful. What could a future governor do about reimposing the residency requirement?
Well, under the terms of the settlement, certainly the executive branch of those departments, and perhaps at the behest of the governor, could change essentially the standing order that was given to those departments. And if they did that, we would likely sue them again. I don't know that we would try to necessarily enforce the settlement. We would just go ahead and sue them.
Right. And that's what I want the people listening and watching to understand, is that the settlement is an agreement to resolve this lawsuit because you got what you wanted, the ability for people to get Nick's care and from his colleagues. But this could still be an open issue until the legislation is actually adopted. Do you think that's where we're headed?
All signs right now are pointing that direction. We know it's a priority bill for that department, and it's pretty much a straightforward fix to the law. I don't think that there's a mood in Oregon to start rationing or limiting healthcare for care that the state doesn't necessarily pay for, from people that are coming in from other places or happen to be visiting or whatever the case may be. So I think the legislative chances of it passing are actually quite good, and I'm hopeful that that will be really the end to the legal issue, at least here in Oregon.
Interesting, very interesting. So, Nick, back to you. What do you expect to change in your practice when word of the elimination, or at least for now, the non-enforcement of the residency requirement gets out, and people start calling you, start calling advocacy organizations? What do you think this is going to look like from a clinician's perspective?
Well, it certainly started to happen. As the named plaintiff in the case, that meant my name was available and I'm not too hard to find. So it didn't take long from the announcement of this, I'll call it a victory, this measured victory, for sporadic interest from states where medical aid and dying is not available. for patients to begin to approach me and for me to begin to get messages. I'm in a fortunate position of having the time to be able to answer most of those calls, and found that most of them, like most conversations about aid and dying, are at least initially about bigger issues, about how else can your needs get met, about what are you most afraid of in this situation, and the general counseling that occurs around that. And so most of the calls ultimately ended in me giving, not specific medical advice, but information about what hospice is about, what good palliative care looks like, what your right as a patient to not continue aggressive or painful or curative treatments looks like. But in some of those cases, it was clear that the patients probably would be eligible under Oregon's medical aid and dying law, death with dignity law. And conversations began to happen about what that would physically and actually look like for a patient to go through the process of coming to Oregon, of receiving the care, finding doctors that they need, a really complex process. So again, this has begun to look now like sporadic, not frequent. I doubt I get an inquiry a week. It's probably more like every couple of weeks. But for which some of those conversations have become material. And in fact, since we first began to plan this meeting just in the last week, as a hospice medical director, I have assumed care for a patient who has relocated from a state. I don't think there's any harm in saying he's from Texas, with ALS, otherwise known as Lou Gehrig's disease, a very difficult illness, which in Oregon is the illness for which people are most commonly are most likely to use our Death with Dignity Act. And he is in the process of, coming to Oregon, probably for not more than a few weeks or a month. Though again, we'll see what happens. We'll see how else we can meet his needs in the hospice situation. But that's what this has started to look like. Not frequent, not, tons of people coming from all over, but for a small number of patients who otherwise qualify or determined to go through that and have the energy and the resources. I think there's a lot of barriers to simply coming to Oregon to make use of this law if you're from another state, but it has started to happen.
So of the calls you've been getting, just a rough guesstimate, are most of them from people right in the Oregon sort of crescent, so Washington, California, or are you seeing people from farther away?
It's been both, but given that Washington and California have legal medical aid and dying at this point, and so many states that don't, the majority of the calls by a long shot have been from other states.
Got it. And I'm gonna guess that if people are calling you from outside of the Pacific Northwest, they're calling from states where this is not available. Is that about right?
Right.
So, Kevin, what kind of advice would you like to offer? Not legal advice, but educational advice about how clinicians in Oregon and clinicians in other states who maybe want to refer a patient to a clinician in Oregon. What should they be thinking about? What should they be concerned about? What's your view?
Yeah, that's a good point. Just to go back for a second, I also wanted to just highlight that this case is in some ways is a stopgap measure. Obviously, the key is that all states have authorized medical aid in dying. No one should be forced to leave their home, even if it's only for a temporary basis, in order to get the medical care that they want, especially if it's easily available. It's not like medical aid in dying requires a multi-billion-dollar research center in order to go through the process. I think the most important thing to remember about people who are coming from out of state is that we still need to maintain, or the clinician still needs to maintain, an incredibly high standard of care for that patient. which means really looking at the patient as a whole, being able to satisfy all the requirements under the Oregon law, which includes being their attending physician. In other words, treating their underlying care as they are at the end of life. And that's really critical. You know, part of this, part of the question or the dialogue when educating people about the pros and cons or risks associated with out-of-state residents coming to Oregon is how much risk are people willing to accept? And largely it's not a risk that's posed to the individual, the patient. It's really risk to both the physician and then the loved ones or people that are helping the person either make the journey or be there to support people, or whatever the case may be. So if you are going from, say, an authorized state to another authorized state, so the circumstance of going from Washington to Oregon or California to Oregon, something like that, the risk is exceedingly low that you're going to see a successful prosecution, even a prosecution actually, of any sort of crime. Because you have to remember that in many states, even when medical aid in dying is authorized, the assisted suicide statute still exists. So if you're in a state where there is no medical aid in dying statute, but they still have the assisted suicide statute, it really takes an individualized analysis of not just the state law and kind of whether or not they follow the model penal code in when the crime is perfected and whether or not someone can then go back and charge, but also a really individualized assessment of the local jurisdiction from where people are coming from. And what's that prosecuting attorney like? Is the DA someone who's a very kind of reasonable person or has other kinds of goals? Or is it someone who, for whatever reason, might be willing to kind of take a stand on some sort of ideological issue and go after someone who is seeking this kind of care? Those are things that, I don't know every single jurisdiction, but I do know that, for example, in Idaho, there are, there's some pretty extreme things happening right now, and they border Oregon. And so I think the best advice that we give people is if your risk tolerance is low, all of the activities related to the qualification process, the filling of the prescription, and the self-administration really needs to take place in Multnomah County. That way you are the most protected, Multnomah County, Oregon. So that's where Portland is.
Right.
That is where the settlement protects people the most. So if you're low tolerance for risk, all of those things. That also means even with telehealth, the person should be within the borders of Oregon when they're making that call. If it's a call for a request or the qualification process. So, and unfortunately, it just, it opens up too many avenues for difficulties if people are using telehealth to go into an unauthorized jurisdiction, both for the physician and the licensing issues, and then also because of the possibility that you could open yourself up to potential criminal issues. We'll see the family members open up to criminal issues.
And Kevin, just to be clear, you're talking about the initial phone call to even inquire about a particular physician's availability to provide this service, right?
If your risk tolerance is low, then yes, I would say every aspect related to medical aid and dying. I think the critical part is, it's one thing to call and say, are they available for a consultation? I have questions about this, whether they're actually providing this or not. That's different. But as soon as you start getting into anything related to the qualification process, it's really important that it all take place in Oregon.
Which makes the important point that there's a role for advocacy and education organizations like Compassion and Choices and the Completed Life Initiative to make sure that patients who are even thinking about utilizing the elimination of the residency requirement know how to do it right and know how to do it safely. And we ought to acknowledge, right, that this is a political question. Many people have strong feelings on both sides of the issue, and it serves everyone's purpose on both sides of the issue for us to be mindful and careful about how this plays out. So let me go back to you, Nick, and let's talk about that notion of administration of the medication within Oregon, because I imagine that what we will need to be thinking about as a support community going forward, as word of this becomes more widely recognized, is the two kinds of patients. The patient who is seeking out help in Oregon because they have an immediate need. And to Kevin's point, maybe they're going to come to Oregon, get evaluated, get the prescription, and utilize that in a setting within the boundaries of Oregon, versus someone who wants, as we know is so often the case, to have the medication so that they have that measure of control. And how do you think about counseling patients? How important is it to you to know which category they fall into, immediate or down the road?
Very important, and specifically, it's because again, this is not something that my medical mind goes to right away. But as Kevin said, there are these risk assumptions for, especially for the patient, especially for their family members, but also additionally myself, and by implication, the rest of my patients, the hundreds of patients who rely on me for all their medical care, the roughly 120 patients for whom I'm their hospice medical director, all of them, of course, make me risk averse. So again, back to your question, for the patient who's here in an immediate need, and it's the standards of care that we now have as well established. All the, as Kevin mentioned, all the aspects of the law, the 15-day waiting period, the second physician consultation also occurring here within the borders of Oregon. And again, I mentioned this because it starts to add up what we're asking someone to go through, what the process someone's going to need. And I'll share one conversation from a patient from one of the Carolinas where it really became clear as I was providing information about what coming to Oregon would look like. You know, the patient was in hospice. It seemed pretty clear that they would meet those requirements were I to be face-to-face and meeting with them. But it became clearer and clearer over the course of the conversation that not only would they need to keep thinking hard about the options they do have in their own state, you know, generous and aggressive palliative care, potentially voluntary stopping of eating and drinking. But that patient knew more about this than I did, but of course, but had pursued going out of the country, going to Switzerland, for example, to go through the process, and that actually would be likely less burdensome for them than coming to Oregon and meeting all the requirements we would here.
Right.
I hope that helps answer your question.
You're talking about organizations like Pegasus and Dignitas that provide medical aid in dying in Switzerland under a very different and broad set of circumstances.
Yeah.
And of course, you know, the East Coast is much more accessible to Europe than the West Coast, just in terms of travel, especially for patients who, by definition, have a terminal illness and are nearing the end of their lives anyway. And we'll talk a little bit about those travel options in a few minutes, but I want to stay on this question of how you clinically are approaching patients based on whether they have an immediate need. That is, they're going to be taking the medication, if not as soon as they get it, but they have an immediate plan to utilize the prescription that you provide, versus those who just want this in place so that they have control over their end of life
Right.
experience?
Well, in the latter, I'm somewhat like Kevin, but from a more medical point of view, I'm providing information about options that are available for any patient anywhere, really,
Mhm.
but certainly in a place that doesn't have medical aid in dying, what good pain relief, good palliative care looks like, making sure folks getting enrolled in hospice, making sure they're having direct conversations with their physicians about how they're feeling about their current kind of care. Is there a need? It's okay to say no to aggressive care if it's not meeting your needs anymore. And sometimes patients just need to hear that, right? They need to have a practice conversation. Um, for the patient who has immediate interest and has the ability to come to Oregon, we're trying to set it up such that in particular, most folks should be in hospice when they have a terminal diagnosis. Should at the point that they're foregoing curative treatment, they should be seriously considering, if not enrolled in hospice. So for the patients, the now much smaller number of patients who've called me who already are in that kind of position, um, in a very concrete way, I'm trying to refer them to support for finding a place to come to. That often is meant, one patient had a brother who lives here in Portland. So that would, be the obvious choice for them. And there are reciprocal arrangements hospice can make when you plan to travel as a hospice patient. So hospice A, where you are, contacts hospice B here in Oregon and sets up a transfer of your care, temporary or not necessarily permanent, because you're not changing residency, you're going for a short period of time, but a temporary, because again, as I think Kevin mentioned, there's the responsibility to not bring patients to a place and then have their needs go unmet, right? I might be their consultant for medical aid in dying, the so-called attending or prescribing physician. I certainly have an obligation to not set them up for failure. But if they need other kinds of medical care, they should have a way to get that. And that's in particular with the transfer of being enrolled in hospice and then arranging a transfer of that hospice care to where you're going to be in Oregon, often where the next part of the conversation comes, right?
Absolutely. Let's follow up on that, Nick. Talk to us a little bit about what kind of a experience a patient should expect if they travel from North Carolina or even, New Mexico and come to Oregon for evaluation, for the second examination by a concurring physician. Time frame, what they can be doing in the
Sure.
meantime. How does that go?
Well, again, I want to provide the caution to the folks on the call today that this is still something we're formulating, right? We don't have a set track. We don't have a pre-composed package that gets you your housing needs and who might be with you and what volunteers. But the components are available, right? We have a wonderful organization. I'm on the board, but End of Life Choices of Oregon, that has begun to think through what matching a volunteer coordinator, what a volunteer that can be with the patient, finding places where a patient might be able to stay if they can't find that on their own. But the very minimum, the patient's looking at being here for over 2 weeks, because there's the 15-day waiting period and the day after you submit your final request, your written request, for example, to get the prescription. So probably something more like 3 weeks, where you'll come. One of the first orders of business will be to meet with the prescribing physician. Let's say that's me, and make a true medical determination based on that case and that patient's diagnosis and situation, whether they qualify. Hopefully they've gotten good information, so that's not a surprise judgment, that can be relatively assured until it's actually met and formally determined. They'll need to meet with another physician to consult and confirm a number of items, but primarily that the patient has the terminal illness and that they're competent to make this decision. Finish up a written request. Not too hard there. That's easily available on the web. It's something the state of Oregon publishes. It's simply another formal way of writing out what's needed, but you do need a couple of witnesses. It takes a little thinking through. And then the final request. And then at that point, as long as it's not a Sunday, going to one of the pharmacies that provides the compound prescription that we use, and then having a safe, non-public place, comfortable, with, I mean, it's the patient's choice how they do, but they should not be alone, absolutely should not be alone. And from my medical perspective, should have someone with them who has experienced this kind of life completion before, right? So that can be a volunteer from the advocacy organization and Life Choices Oregon. That can be their hospice nurse from the hospice they're enrolled in, if that hospice participates, which most do at some level. Or that might be me. But they should have someone who's had that kind of experience, something like it around. That's certainly our best advice. So putting all those pieces together, we're looking at substantially over 2 weeks, probably 3 weeks would be the shortest you could hope for. For the patient who has both that level of terminality and the stamina and the ability, I suppose they could do whatever they wanted during some of that waiting period. For example, returning home. To return back to complete the components that we need to complete within the state. So that's the kind of thing that I think it will look like.
Indeed. Kevin, the first thought that crosses my mind as a lawyer, as an ethicist, and as a professor of bioethics is the health disparities issue, right? This is something that requires substantial financial resources. And how does that play into the legal argument about both the privileges and immunities clause implications and the equal protection clause implications? It seems as if even if the advocacy groups really step up and make resources and support available, everything from housing or introductions to people who might be willing to provide their own homes, access to end-of-life doulas. Will we have enough end-of-life doulas? Where does this fit into the legal arguments that might occur going forward as this effort takes shape and starts to grow?
Well, I think the equity issues are huge, and those issues are issues that plague our entire healthcare system. And I think that's one of the, I'm not an expert in the Canadian law by any means, but I think that, one of the reasons there is a difference in their law is also because of their healthcare delivery system and some of the guarantees that are afforded the citizens of Canada. We have a long, long way to go in this country to kind of to address those fundamental disparities. And that certainly applies to the end of life context as well, and something that I know Compassionate Choices and other organizations are very committed to looking at and considering. I don't, I think that, given that people don't have a fundamental right to medical aid in dying, I think that any sort of arguments related to equal protection or some of these other things in asserting that there's some sort of economic barrier to accessing it are going to be quite difficult. But from a just kind of an organizational and advocacy perspective, they are really critical and something that I know myself and others are always thinking about. And how can we make this more equitable? And I think that actually the issue of forcing people to travel needlessly or disrupt the continuum of care by changing physicians because of this artificial rule actually did a small was in a small measure a way to address some of these inequities, because you were essentially making it more costly and more difficult for people to access medical aid dying where they otherwise would have been able to do it if this rule wasn't in place. So I think each step, each kind of layer of the onion that we take off in the inequities circumstance leads to yet another one that we need to address. And so I don't think that work is ever going to end. But I definitely appreciate you highlighting that.
And I should mention as an informational point for our viewers that there's a similar lawsuit to the one in Oregon in Vermont right now. So we could eventually conceivably have a location on either coast. What are your thoughts about what that'll do to the health equity argument, and then what's the next step after that?
Well, it's our position that all the residency requirements in all of the authorized states are unlawful, unconstitutional. So I think that the hope is, of course, that those legislatures where there's a medical aid dying statute will preemptively change their law and follow, hopefully, Oregon's lead. But if they don't, I assure you that we will be going down our list and asking them to do it in a firm but respectful way.
And just so everyone understands, Kevin, can you sort of just sketch out what is the privileges and immunities constitutional argument? Why is it a violation of a constitutional right to restrict access to a form of care based on which of the 50 states and territories somebody resides in?
Yeah, in broad kind of layman's terms, it really has to do with states setting up barriers to other members of the union, other citizens of the country. And rather than having 50 different fiefdoms with particular laws like, oh, you can't buy a weapon in this state, or you can't buy popcorn over here, or take something from one state to another, just because you are a resident of another state. I think that the framers of the Constitution said that would be incredibly unworkable, and then we really don't have a union. And so they included this provision in the Constitution, which in this context really has to do with the accessibility of healthcare. And remember, this isn't state paid for healthcare. This is something that folks often have to foot themselves. So there really is no detriment to the state in having people come here and actually obtain this care. And that's given that, it just doesn't make any sense. So, and if you think about how healthcare is delivered in this country and how people obtain healthcare, I mean, I've had clients that get on planes and travel on a regular basis for healthcare, whether it's because they're in a clinical trial trying to find something that will help alleviate or cure their terminal illness, or whether it's because they just really have a belief that the people in a particular institution are the best providers for them and understand what they're going through, and they want to pursue that. And so the state, because of those provisions in the Constitution, really has no role in saying, no, you have to go to the doctor over in your local neighborhood, and if there's someone that's just 5 miles away across the border, because they're in another state, you can't access that care. That's just not how our system was built.
And we should mention, in the context of the cost and who pays for this, that state boundaries also have implications for your health insurance, especially if you're a patient who participates in a managed care plan. And that's something else that we will have to be looking at as a society, and lawyers in particular. I'm curious, Kevin, what you think of some of the sort of analogous issues that have been in the public square recently and will going forward. I'm thinking right off the bat about marriage equality for citizens who are gay, and the looming question with the Supreme Court decision in Dobbs overturning Roe versus Wade of people traveling across state borders to get reproductive health services, including contraception and abortion. Do you think this is going to be part of the legal discussion that we're going to have to be having going forward?
Yeah, I mean, whether we want it to be or not, it certainly is going to be part of that discussion. And I think that, it was interesting after the decision in Dobbs to suddenly have people talking about the privileges and immunities clause and other things. Because before, it felt like we were the only attorneys that were very excited about this in this particular context. And all of a sudden, there was a lot more interest. Um, you know, in in thinking about the actual implications on the ground, and just to be clear, with the reproductive rights issues, oftentimes those are states that are trying to um, keep people from leaving their state as opposed to going into their state to obtain care.
Mhm.
So there is a little bit of a difference. I think that the case that we are watching that gives me the most pause and wondering whether or not it will pass constitutional muster is the case that deals with the what they're calling the bounties in Texas, and whether or not this kind of system of allowing private individuals to sue and obtain fines and or attorney's fees for people who obtain healthcare abortions, if that is something that is constitutional. Because if it is, it's really a workaround on people's being able to obtain or exercise their constitutional rights in many forms. And so it'll be interesting to see what happens with that particular case.
Yeah, I think those of us who do education and advocacy in end of life issues need to be cognizant of the fact that the Texas abortion, what we could generously call the private attorney general model, where private citizens can act as law enforcement agents, um, could well present itself in the discussion about what we're talking about today, interstate use of medical aid in dying. Do you see that as a issue you're going to have to confront as a public interest lawyer?
I fear that if it's constitutional, I think everyone as a lawyer is going to have to be thinking about it, because all of a sudden you're going to have to understand what the laws are in all sorts of other different states in order to be able to properly advise your clients. And my hope is that it's not something that's going to pass constitutional muster, but I think with this court, we just don't know.
I think we're going to find out sooner rather than later. So, Nick, let me turn back to you about the all-important issue of the standard of care. And
Mm.
here I want to look at the standard of care for the patient while they're in Oregon and the standard of care for patients when they choose to return home with a prescription in hand. So, to the extent that you are, in effect, taking a referral of a patient from another state, it may not be a formal physician to physician referral, but you're assuming care for someone, and then they're going back to where they came from with your prescription in their hand. What is it that you want to be sure of as a clinician in terms of the kind of medical support they're going to get during the remainder of what is presumed to be about their 6-month prognosis with their terminal illness, with your prescription in hand?
Well, I want to emphasize that for my patients in Washington, like I've talked about, the ones who maybe have an established relationship with me or have come in consultation, but they're from a state where medical aid in dying is legal, then I'll be pretty darn comfortable that they can go home with that prescription in hand, and administer in the ways I've already described, safely at home, non-public place, maybe with the knowledge of their family, but certainly with the presence of someone else who's comfortable with what's going on and maybe even has some experience with it, end of life experiences, life completion, medical aid and dying. Um, If they came from a state where it was not legal, I'll say not legal yet, um, uh, then we're going to ask them to stay in Oregon for that ingestion.
Mhm.
I suppose once a prescription is issued, I can't, physically control what happens at that point. But I know everything will have been done in my determination that the patient has not only known this but agreed before I wrote the prescription that they would take it in a place where medical aid in dying is legal to avoid those risks, more to them and to their families than to me, but both.
Mhm.
Um,
So
mhm.
that's really interesting. So, as a matter of standard of care, both as a clinical issue and, in effect, a sort of a risk management issue, is it your intention to tell every patient who comes to Oregon from out of state that I would like for you to come back to Oregon when the time comes to take
Yeah,
the
you should be
medication?
here for the entire process. Absolutely. So again, that's another high barrier, right? With my other patients, with this conversation can play out over time in incremental fashion. If someone's investing all that energy and effort, unfortunately, of course, we always counsel that they can change their mind if their goals for a completed life are being met without using a medical aid and dying prescription. That's wonderful. I'm glad that that can be obtained. It's one of the reasons that I know I personally will be, pretty darn sure that people, if they don't have actual that they have hospice care while they're here. I can imagine a circumstance where all those components are completely available to them and they've been taken care of, but essentially they'll need to be in hospice, for example. Now, what we've seen, and I guess Oregon has been a lead in this, that the statutes in almost all the jurisdictions look a lot like Oregon's law. We know what the standard of care looks like. There's now an academy for medical aid and dying. We know what what's really clear is needed. Um, that that you understand your options. That I've already mentioned who's around when you take the prescription. That you're medically able to self-ingest in whatever form you ingest. That this is not administered to you. This is not euthanasia, but
Mhm.
this is a patient self-administering the lethal medication. All those components are fairly clear, and I hope that just starts to answer your question. I could get into it quite a bit more detail.
Yeah, no, that's actually where I was going next, not surprisingly. So let's talk about the routes of ingestion as a term of art, both medically and legally, um, under the broader category of administration. But let's hold on that for just one moment, because I want to go back to Kevin and talk just for a moment about the lawsuit that is currently pending regarding the application of the Americans with Disabilities Act that says that the requirement for self-administration is itself a violation, not per se of the Constitution, although you could make that equal protection argument, but a violation of the Americans with Disabilities Act. Where do you see that going in this larger public policy discussion?
Well, I have been following the case. I think they've got a hearing scheduled. I have not reviewed the latest complaint. So my understanding is that the judge dismissed the case and ruled that it would be a fundamental change or allowing the relief would be a fundamental alteration of the program, and therefore it does not violate the American with Disabilities Act. Since that point, I believe it's possible the plaintiffs at that time may have passed away, and so I'm not sure kind of what the status is right at this exact moment on
Right.
that case.
Yeah, the lawyer who's handling that case, Catherine Tucker, will actually be speaking at the afternoon session of our conference today. And I'm sure that will come up in conversation. And sure, there are some procedural issues standing an available living plaintiff, whether the notion of the self-administration requirement falls within the application of the Americans with Disabilities Act. These are all technical questions. There is the larger values-based or ethical question about whether we ought to be, in effect, discriminating against people who lack the ability to roll a roller valve on an IV tubing or push a plunger or swallow. And I think that will inevitably become part of the larger conversation, especially as the option to travel to Oregon becomes better known in states where medical aid in dying is not available. And some of the patients who might want to take advantage of that aren't able to engage in all of those mechanical processes of self-administering. So I think that's going to be part of what the future holds for all of us.
Well, I do think it's important to remember that at one of the hearings, the judge essentially asked, "Are you advocating for euthanasia?" And the response was yes. And I think that given the current court and given what happened in Glucksburg and other cases, the likelihood that this sort of claim with that sort of relief being requested, being successful, is there's some high hurdles that need to be met, and we'll see. We'll see how it plays out.
Yeah, and we should be clear that those hurdles, while they are real, there have always been hurdles that had to be overcome in public interest litigation. And the practical reality is that applying a single definition to the term euthanasia is probably outdated at this point. In Canada, they don't distinguish between self-administered and other administered medical aid in dying. That is, in fact, the topic of this afternoon's program. So I think there needs, and this is part of the ethical discussion about end-of-life care, there needs to be a distinction between active and passive and voluntary and involuntary euthanasia. Those are four entirely different subjects. And it may well be, and I'd be interested to hear what both of you think about this, that we need a separately defined phenomenon for someone who wants to self-administer and can perhaps even initiate a physical gesture but doesn't have the strength or the dexterity or the coordination due to Huntington's disease or Alzheimer's or Parkinson's disease. Do you see room both legally and clinically for that distinction?
I'll go ahead.
Please.
Just in contrast to what we're talking about, the residency requirement. For me, it's been really clear, and I joined the suit because that felt like a much more arbitrary requirement, whose time, may have been early on when Oregon was the only state, but whose time had passed and was providing a real barrier to patients I knew and cared about. It also seemed that for patients who lived in states without medical aid and dying laws, this could be a real avenue towards aid and comfort for those individuals, as well as perhaps a chance for those states to rethink what their citizens need and want. The self-ingestion requirement is more complicated. One asked myself, having never had to administer a lethal dose of medication, it is a different step. I essentially agree that it's fairly arbitrary, and I suppose if my patient needed it, I probably could and would. But that requirement for self-ingestion has stood the test of 20 years in Oregon is sort of final proof of voluntariness, right?
Yep.
And while in a relatively small number of court cases, we've come technical ways to overcome some of the difficulties that many patients would have with self-ingestion, whether that's a feeding tube and turning what might have been difficult swallowing into a more mechanical act. We've begun to use rectal administration, which can remove that barrier in another way. We've had a number of ways to incrementally make self-ingestion easier. But as a final and clear line of the determination of voluntariness, it stood us well. So there I do feel it's a much more interesting question, let me put it that way.
I think it is a more complicated legal, ethical, and clinical question, to be sure. I feel like Kevin wants to say something.
Yeah, I just wanted to add that, going back to the equity issues that you raised, we're at the 50th anniversary of the Tuskegee experiments. It's just been a couple of years ago since we realized or got wind that women held in ICE detention centers were being sterilized without knowledge. I think that that absolute proof of voluntariness is something that is really critical when thinking about the equity issues that are at play here. And I think also that this sort of change may be best suited for the legislative arena so that people can demonstrate that there actually is the broad support, as opposed to going the judicial route where you could actually, given the court that we see some sort of backlash or some sort of attack, or that is used as a vehicle as an attack on the fundamental ability to obtain medical aid and dying.
Kevin, I couldn't agree more. I think tangible, identifiable, documentable evidence of voluntariness is indispensable. But I think there are more ways of doing that than are immediately obvious. The reason I raised it in our session today is I do think it is part of the implication of the elimination of the residency requirement in Oregon, because patients, notwithstanding the good clinical advice that Nick gives all of his patients to come back to Oregon for the ingestion, patients will have the legal right to keep that prescription in their home state and administer it. And I think it may well be a reason why other states that haven't yet sort of dealt with medical aid and dying will want to, so that they can impose their regulatory influence on the routes of administration. And Sarah, if you will bear with me for one more moment, I just want to reference the discussion about the routes of administration. So they are obviously oral, which is clearly what everyone had in mind when the Oregon law was passed. Rectal, which is just the other end of the canal. Nasogastric tube, which kind of blurs the distinction. And then finally, intravenous. And when you start thinking about rectal administration as one kind of a catheter, a tube, and nasogastric, another kind of a tube, an IV is another kind of a tube. So in terms of the rationale for restricting self-administration for someone who travels from Oregon to a state that doesn't have a medical aid and dying law, I think this may be a compelling reason why those states should take up the discussion so that they can participate in the discussion and the creation of the standard of care, rather than being sort of just passive participants in the decisions made by patients. So I'm going to leave it at that point for now, because I'm guessing, Sarah, we may have a couple of questions.
Indeed. Thank you, David. We have some good questions coming in from the audience. To begin, Sue had a question about to what extent are pharmacists at risk legally, especially with an aggressive DA, for example?
Who wants to take that first? Kevin, Nick? I have some thoughts, but
Why don't you go ahead?
well, Nick, let me turn the question into a medical question. When you write a prescription, do you write on the prescription, this is a prescription for medical aid and dying, or are you writing a prescription for a medication?
I'm writing a prescription for medication. But if you look at what the formulation is, that's all that it could be for, right? It's 500 to 1,000 times the normal dose of those medications involved.
Mhm.
I know what I'm writing it for. Does the paper say that language? No, I don't think it does. Some of the medications around it, the anti-nausea medicines, do say, 1 hour before lethal ingestion or 1 hour before planned ingestion of lethal medications or of MAiD medications. So in that sense, there's probably a paper trail. I
So-
want to reflect back to on the pharmacist question. I really remember, Oregon, we have it. The prescription needs to be directly delivered to the pharmacy, so mailed, or there's been a number of times where when a patient's been in a rush, I've driven the piece of paper to the pharmacy. And well, the first prescription that I did that for in Oregon, it was quite clear that the pharmacist participating was to the right side of the political aisle on many issues. Weapons freedom, for example, Second Amendment, a couple of other things were really pretty declared in the workspace. But for my colleagues or our patients, our listeners who are in states that might be more identified as red, this is an issue of individual autonomy that really can come around. There's not just one perspective on this. And folks who are very interested from a libertarian point of view, let's put it that way, or otherwise in autonomy, fully get this idea. So in terms of pharmacist participation, I suppose the risks are similar to the ones that and smaller than the risks that a patient or a family member might take if an aggressive DA were to enforce assisted suicide issues. But I know that pharmacists I definitely know many pharmacists who share the passionate belief that we're really helping people at the end of life when we make all options available.
I would just add that I think that you would want to make sure that the prescription is filled by a pharmacy here in Oregon. And that is particularly true given the prevalence of prescription drug monitoring programs in a number of states. And so, if there is the fear of a overzealous prosecuting attorney, district attorney, depending on the state or the law enforcement agency, they may or may not have access to that sort of database, and the state may or may not require that certain elements of those prescriptions get entered into that database. And someone that could quickly search for certain combinations, depending on the capabilities of that database, would easily be able to identify what is going on. And unfortunately, it's something that in litigation that we were involved with quite a few years ago, actually were unable to kind of stop that from the federal agents subpoenaing through administrative subpoenas that kind of information, even though the state law here in Oregon was very clear that this was a tool not for law enforcement, but really a tool to make sure that people are getting the best possible care, and that people are able to identify those who are, drug seeking essentially, and provide that additional help to them as opposed to just providing more drugs.
Kevin, I couldn't agree more. And the import of my question was around whether a pharmacist in Oregon ought to be entitled to interrogate a patient about why they're getting a prescription filled, even though, to Nick's point, it's pretty obvious on its face what the standard use of the medication would be. And if the anti-nausea medication specifies that, that would be clear documentation. Frankly, Nick, something that we may want to think about. But the broader legal and ethical question is whether a pharmacist ought to be interrogating a patient about their intended use of a lawful prescription.
I will say that's essentially mute here. It's required reporting when filling a prescription. So in that sense, it's fully acknowledged, and I sort of forgot that part. But just like I submit to the state because of Oregon's unique laws and first in the nation status, we've kept really, really good data. But part of keeping that data is that I have to submit paperwork, and so does the pharmacy.
No, absolutely. And that is a regulatory safeguard that I think serves a valuable purpose. It stands apart from the broader professional ethical question of whether pharmacists ought to be acting as gatekeepers for medicine based on use or intention. And I think that's to the point that the questioner obviously was focused on. That's something that we will need to be thinking about some more. Sarah?
So another question regards this issue of self-administration and versus physician administered. So Margaret has mentioned that an anesthesiologist can set up an IV line running normal saline with a roller valve that the patient operates him or herself or their self to infuse lethal medication. Would this perhaps qualify as self-administration, quote unquote? And similarly, a separate but related mention from Marcia, that at Pegasus, a Swiss right to die organization, a doctor puts the IV into the patient's hand, but the patient must move the dial themselves. So with this, where this method is available, there's data that indicates that people overwhelmingly prefer it. Is there any possibility of this being approved within the US?
So let me say from a medical ethical perspective that it is hard to reason your way through distinguishing between different kinds of tubes, but that's a medical ethical analysis. And I'll turn to Kevin to explain what the Oregon law does and does not permit in terms of use of tubes for administering, or to use the technical language, ingesting the medication prescribed for medical aid in dying.
Yeah, as the questioner noted, it's not lawful here in the U.S., and that includes Oregon. And maybe Dr. Gideonse could talk a little bit about ingestion and what that means versus, say, an IV. But to the question of whether or not that change is likely, I have not heard from any legislative body that there is a groundswell of support for that particular change. I think that oftentimes there would be one or two people in a legislative, assembly or body that might be interested in it. But overall, for whatever reason, it just doesn't seem to be something that legislators feel comfortable with at this time.
I will say, I'm sorry, go ahead, Nick.
Yeah, I'm going to add to that in that, particularly since we've developed we've always had the NG tube or gastric tube option available for self-ingestion. So I feel that the number of patients this affects is very, very small, not zero. And as was mentioned in the question, there are certain sort of comfort issues that are real in terms of ingesting 4 to 6 ounces of very bitter liquid that can be a little burny at times, depending on the compound you use. But with the alternatives for things that still meet the definition of self-ingestion as opposed to self-administration, while not disagreeing that the fundamental moral or ethical difference is quite small or may not even be a true barrier, fundamentally for the hundreds of patients who've used this, it's been a very, very small number where that's come into the equation for me, where that would really have made all the difference.
I do think that this will become a more important part of the discussion depending upon what happens with the California lawsuit that Catherine Tucker is pursuing over Americans with Disabilities Act application, because when we talk about a requirement for self-administration, for some patients, especially those who have tracheal or esophageal obstructions, IV administration with the patient opening up the roller valve may fit the definition of a reasonable accommodation.
So jumping to a question from Rebecca Brown, who's an end-of-life advocate up in New Hampshire. She's wondering, what do you think of states like New Hampshire that does not have legal access to MAiD, but is situated between Vermont and Maine, where it is legal, considering legislation to exempt MAiD from the Assisting Suicide Criminal Code?
Kevin, you want to take a shot at that?
Well, if they were to exempt it, then I think they would essentially enact medical aid in dying. I doubt they would just simply make an exception for assisted suicide without also going into kind of the regulatory framework related to medical aid in dying. I think that the more explicit they are about that, the better. I think that one of the things that we have learned and we have seen is that the fact that we have had to go state by state to get authorization for medical aid in dying generally means that it is relatively safe in those states. In other words, politically safe. That it's unlikely that it will be suddenly repealed. Of course, courts can do all sorts of things, but because of all of that hard work and education and of both the populace, physicians, and legislators, that really has helped turn the tide. So my hope is that, of course, we see this in all states. I hope our suit in Vermont is successful, so at least there's some increased access for folks in New Hampshire. But I don't know what's going to happen in the near term in that particular state. I think we'll have a better sense as the elections and the midterms come about, and we see all the different governors kind of take their seats in the coming year.
I would
I'll
just
just
add,
piggyback on.
go ahead,
I'll just
Nick.
piggyback on and say, essentially backing up what Kevin said, I'm sure that would be helpful if I put myself in the position of a prescriber in Vermont, it wouldn't hurt to have that. But if you're going to go to the trouble of passing a bill, follow Oregon's example like so many other states have and just pass the whole package.
Yeah, I agree. I think the answer to the question is that anytime the phrase assisted suicide is in a discussion, the discussion's going in the wrong direction. And the greater likelihood is that once Vermont gets rid of its residency requirement, New Hampshire will sense the obligation on behalf of its citizens to apply its own regulatory framework through its own medical aid and dying statute, rather than being the passive recipient of the legislative judgment of Vermont, the two states having that very long border that they share.
Indeed. Thank you. So we unfortunately are running out of time, but this is good. Last question from another Rebecca in the Pacific Northwest. She's from End of Life Washington. They've been getting a number of calls from folks out of state wanting to access MAiD in Oregon, or rather in Washington, and she's been directing them to Oregon. So she's wondering, and I think this is the question on everyone's minds, whether it's helping patients from Texas, Arizona, etc., as per other questions in our chat here. How can advocates and other end-of-life providers best help you help them? What is the critical information that we should be sharing when telling them to contact folks in Oregon?
So we do have some materials on our website, compassionandchoices.org. They're web pagers, both aimed at family members, patients, and then also physicians. And there's some just general guidance and education about what to do as it relates to the residency requirement. And then, of course, if advocates in a particular state are interested in bringing their own residency suit with our support, we'd be happy to talk to them and kind of see if the time seems right and how we might be able to put a suit like that together.
I do think that this whole discussion we're having today is just the tip of the iceberg. There is so much more work that needs to be done legislatively, in the courts, but most importantly, in terms of patient advocacy and making sure that every clinician in a non-MAiD state knows that they both can and should inform their patients of what is available, including a visit to Oregon, as part of their informed consent for whatever treatment they are providing, right? Risks, benefits, and alternatives, risks and benefits of the alternatives.
And I'll mention that End of Life Choices Oregon is a resource for this. We're a small volunteer-run organization. So, I definitely have deeply appreciated and used the Compassionate Choices material as information material for my patients. But another option, especially as people get to Oregon, is End of Life Choices of Oregon.
Wow. Thank you both so much. This has been an incredible conversation, and it's been a delight and an honor to have you on the Completed Life stage. So thank you all so much. And thank you all to the Completed Life audience for joining us today. Thank you for your great questions. And for those that were not answered verbally, we've been answering in the Q&A box. So take a look at that if you haven't already. If you haven't yet checked out our website, completedlife.org, there's a lot of incredible resources available to either watch or read, archives from our past events, and a podcast, a journal, etc. So be sure to check that out after the recording concludes. And a note about the recording will be published to our website next week after the conference ends on Thursday. So if you had to step out momentarily, feel free to watch playback once that is ready, and you'll get an email notification. Beyond that, our next session, session 2 of day 1, will be starting in 30 minutes. So feel free to step away from your computers, and we'll see you shortly for the next session, Right to Try and Right to Die, Similarities and Differences in How the U.S. and Canada Empower Terminally Ill Patients, with Catherine Tucker, Dr. Sandy Bookman from Canada, and our very own Thaddeus Pope. Thank you all. Be well.
Thank you, Nick. Thank you, Kevin.
Thank you.
Great pleasure.